But we're thrilled to have Kelly Mitchell, the executive director of the Robina Institute at the University of Minnesota School of Law, who also previously served as the executive director of the Minnesota Sentencing Guidelines Commission. So she really knows how these guidelines work. And once again, we're thrilled to have back criminal defense attorney April Preyar. Good to see you both. April, let me start with you. What do you think I'm getting wrong here?
I'm not sure you're getting anything wrong, especially when you point to the other defendants who have gotten about 8 years, just a little bit above what people were expecting Ms. Potter to get. The state's major argument is the first one, that the greater than normal risk or danger or safety to others was created by her actions. So by pulling the weapon, because the mistake, as we know, is not a defense to this crime or really to any crime, and that in doing so, that she shot into a moving car, that she could have injured or killed the driver, the passenger, the other officers, and that car not only as a result of her actions could have caused an accident, but in fact did cause an accident, and Mr. Lundgren's health has declined as a direct result of this. So I'm saying their best argument is their first argument. I think the second one, the second prong, is the more difficult one, simply by saying that she was in uniform is therefore an aggravating factor. I'm not sure that works.
Right. Let me ask Kelly Mitchell, though. You heard April say that mistake isn't a defense, but it is relevant in sentencing. It's not a defense in this case. She was clearly convicted. They determined she was reckless, she was negligent. But it does seem to me very relevant in the context of sentencing. And it feels to me like the prosecution is setting the standard and comparing it to other cases where people made the decision to be reckless. They chose to do something that was, particularly dangerous in pulling out their weapon and firing. Kelly, am I misreading this?
So, in Minnesota, we do base the typical sentences on the actual offense of conviction, right? So we have to start with, how is this offense defined in the first place? And then the judge does have the ability to take into account the particular circumstances of the individual when actually setting the sentence. So that might be, that might cause the judge to go to the lower end of the range within that cell, maybe even go to the higher end of the range, sort of depending on what's relevant at that time. So that's where the judge, might be thinking about mistake versus intentionality in the way that this crime was committed.
But the range you're talking about is the 6 to 8 and 7 months or whatever it is range, which I think makes perfect sense. What prosecutors are asking for here is more than 15 years, which just seems completely off the grid, so to speak, when it comes to Minnesota law. Am I wrong, Kelly?
So it's not entirely wrong. The way that it works in Minnesota is that whatever the presumptive sentence is, if there are aggravating factors that support an aggravated sentence, a sentence is longer than called for in the guidelines, the judge has the ability to depart up to twice the presumptive sentence. So the judge could go up to 2 times above this 86 months, presumptive range. But the reality is that those cases are rare. And, in the past 20 years, for the 100 cases that have been for people who have been convicted of first-degree manslaughter, only 6 people have been given that 15-year sentence.
This isn't like every other case. I think, April, there's enormous political pressure, not just on the prosecutors, which is the reason I think that they asked for this this additional sentence, but I think there's going to be enormous pressure on the judge to potentially issue a sentence harsher than would ordinarily be the case.
I'm not sure that that's going to be the case. So I think that there are other factors at play. 1, Ms. Potter is a woman. 1, 2, she is a mother. 3, she was a police officer at the time. I think all of those loom large in the judge's mind as well. And the judge is a woman. And I think all of that, whether it gets spoken or unspoken, is going to be at play. I think the judge will have in her mind, okay, if I sentence her to this many years, how long will she be away from her children? So I think all those are factors that are probably weighing on her greater than the political pressure. As we know, judges are supposed to stay middle of the line and be unbiased and not be swayed by political pressure. But yes, the prosecutor's office definitely has that pressure to say, we did everything we could to get this family the justice that they deserve. And now whether it plays out in the way that they hope or not, we have yet to see.
Well, April, and what I like about you is that you do focus on the unspoken, which is the realities, right? It's not just sort of what ordinarily happens. It's the human side of this. And I am very concerned about the fact that it seems these prosecutors want to treat her more harshly than in other cases where people intentionally shot somebody else. And that seems to me to be a complete and total travesty. But we shall see what happens, because none of us know for certain. I am hoping that the judge remains fair and objective in this case. Kelly Mitchell and April Preyar, thank you so much for coming on the show. Appreciate it.
Thank you.
Coming up.